Hello everyone and welcome back to our channel Drishti IAS English. My name is Pragya and in today's episode of Polity Primer, we are going to discuss a very important topic that is in news recently. The title of our today's discussion is Effective Implementation of the PoSH Act. Before we proceed further, let me ask you following two questions. The first question is, did you know about this act before watching this discussion? And do you really feel that women are safe at their workspace or not? Kindly let me know in the comment box below. In this discussion, we will be studying about what is the PoSH Act. We'll also see the history of the PoSH Act. We are also going to analyze its key provisions. We are also going to see the hurdles in implementation of the PoSH Act. We are also going to see the concerns flagged by Supreme Court in its recent judgment, and we are also going to see a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's topic, the Supreme Court in a recent judgment has said that it is mandatory to appoint district officers under Section 5 of the Act. This Section 5 uses the word may, that the state government may appoint the district officers. But the Supreme Court in its judgment has said that this defeats the whole purpose. For effective implementation of the PoSH Act, this provision has to be made mandatory and it is not a directory provision. And that is why the Supreme Court has said that it is very important for the state governments to appoint district officers so as to guarantee effective implementation of the PoSH Act, as well as to report the sexual harassment cases happening at the workplace within their territorial jurisdictions. So this brings us to the question that what is this PoSH Act? So this PoSH Act, or the Sexual Harassment of Women at Workplace Protection, Prohibition and Redressal Act of 2013, is a very important legislation that prevents the sexual harassment of women at their workplace, and this whole act is premised on a landmark judgment of Supreme Court in the case of Vishakha and others versus state of Rajasthan, also known as the Vishakha case. So the ruling of the Supreme Court in this landmark case paved the way for enactment of this act. And if I talk about the history of the enactment of this act, the Supreme Court in Vishakha case observed that there was absolutely no law which the woman could utilize if they are facing sexual harassment at workplace, and that is why the Supreme Court in this case laid down a set of guidelines to fill this legislative gap. And by doing this, the Supreme Court has utilized this power under Article 15 of the Indian Constitution, as well as the Supreme Court has paid attention to international conventions such as the CEDAW. This is Convention on Elimination of Discrimination of All Forms of Violence Against Women. So this convention was also utilized by the Supreme Court while giving the ruling in this landmark case, and hence the Supreme Court has come up with guidelines, and this act was a aftermath of this judgment of the Supreme Court. What happened after this case? That the NCW, or the National Commission for Women, also released a code of conduct to be followed at the workplace. Code of Conduct in the year 2000, 2003, 2004, 2006 and 2010. So this code of conduct was released by the National Commission for Women. In 2007, what happened was this bill was tabled in the parliament, and after many amendments, it finally became a law in the year 2013. So this judgment was passed in the year 1997, and we took almost 2 decades to bring a law to protect women for any kind of sexual harassment that is happening at their workplace. So this is the history of the enactment of the PoSH Act. If you ask me what are the important guidelines laid by the Supreme Court in this case, they are: the first guideline is the employer or other responsible people in a workplace were duty bound to prevent or deter sexual harassment. So this the Supreme Court completely cast a duty or obligation on the employers to prevent any kind of sexual harassment of their female employees at the workplace. Then to set up processes to resolve, to settle or to prosecute in such cases. The employers had a duty to resolve such cases, to settle such cases, as well as to prosecute the offenders in such cases. The employers were also duty bound to support the employees when a third party was responsible for harassment. So, for example, this is the workplace of the woman, and this is the woman employee, and if any third person is entering her workplace and committing sexual harassment against her, then also that person can be made liable by her employer. To sensitize female employers to their rights and the guidelines. So it is mandatory for the employers to conduct a PoSH seminar for all the female employers working in the organization, in which they will be sensitized about what are their rights, what can they do, who can they approach if they are facing sexual harassment at their workplace, and it also explains them about the constitution of the Internal Complaints Committee. If an act amounted to a specific offence under the Indian Penal Code or any other law, employers had to take action to punish the guilty. And not only this, if there was a violation, supposedly this is to a legal offence, and if there was a non-legal offence, or if there was a violation of any service rule, in those cases also it was mandatory for the employers to set up a complaints committee, which later came to be known as the Internal Complaint Committee. So the employers were fully responsible for preventing any kind of harassment that is happening at against their female employees in the organization, and these were the basic set of guidelines, important set of guidelines that were laid down by the Supreme Court in the Vishakha case. Now let us understand the key provision of the Sexual Harassment of Women at Workplace Protection, Prohibition and Redressal Act of 2013, also known as the PoSH Act. So, definition of sexual harassment. So, before we proceed further, let us analyze what is this, the term, meaning of the term sexual harassment is. So, in the Vishakha case, the Supreme Court gave a very broad interpretation to this term sexual harassment. The Act incorporates the definition given by the Supreme Court in this case, and the PoSH Act defines sexual harassment to include unwelcome acts such as physical contact and sexual advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, and any other unwelcome physical, verbal or non-verbal conduct of a sexual nature. So the definition given to this term sexual harassment is very wide. It not only includes physical touching or physical, physically harassing a woman. It also includes her mental harassment. It also includes showing any pornographic content to her or forcing her to watch pornographic content, or it also includes any other unwelcomed act that the woman is facing at her workplace. So the definition is a very wide definition given under the Prevention of Sexual Harassment of Women at Workplace Act. And this act also enhances the definition of aggrieved women. Aggrieved woman. So, aggrieved women is not only that women who are working at an organization, they also include domestic workers, they also include women who are working in informal sectors. In fact, the definition of this term workplace also includes places which the woman visits for her work or any domestic setup in which the woman is working. So the definition of sexual harassment, as well as the definition of aggrieved women or the definition of workplace, has been enlarged under this act to include maximum kind of workplaces within its ambit and to prevent sexual harassment at most of the areas. Then there is prevention and prohibition. The act places a legal obligation on the employers to prevent and prohibit sexual harassment at the workplace. Not only this, it also talks about the constitution of an internal complaints committee, and its constitution is very mandatory in nature. Employers are required to constitute an ICC at each workplace with 10 or more employees to receive and address complaints of sexual harassment. Because why? We did not want the women to face any lacunas of the criminal justice system, and that is why we wanted the parliament wanted a internal complaints committee so as to resolve the women's complaint without any delay and in a time bound manner. Then duties of the employers must undertake awareness programs, provide a safe working environment, and display information about the PoSH Act at the workplace. So this is what I was explaining to you before. They are duty bound to conduct PoSH seminars. They are duty bound to sensitize their female employees about their rights, about the redressal mechanisms in case if they are facing any kind of sexual harassment at work, and they are legally bound to do so. If they fail to do so, they will be liable for punishment under the Act. Then complaint mechanism. The Act lays down a procedure for filing complaints, conducting inquiries, and providing a fair opportunities to the parties involved. So the Act works on the principles of natural justice. Not only the aggrieved woman will be heard, the person who is accused of causing such sexual harassment will also be heard, and a holistic decision will be taken by after hearing both of the parties. Then penalties. Non-compliance with the Act's provisions can result in penalties, including fines and cancellation of the business licenses. So this is what I was explaining to you before, that the employer is legally duty bound to, follow PoSH Act in the workplace. And if he is not doing so, it can even lead to the cancellation of the license. So this is very stringent provision to prevent sexual harassment at the workplace. Now let us understand what are the hurdles that are being faced in the effective implementation of this Act. So the first hurdle is lacuna in the constitution of Internal Complaints Committee. This is a sad reality, but most of the workplaces do not have a functioning Internal Complaints Committee even after the enactment of this Act. As has been observed by the Supreme Court in Wrestling Federation case, only 16 out of 30 sports federation have an internal complaints committee, and this is a sad and an unfortunate reality. Even if they are constituted, they are not working effectively. Why? Because there is a gap in their constitution. Sometimes they do not, they lack members, and sometimes they do not follow the mandatory requirement of having an external members. So even if they are constituted, they do not function effectively. The Act does not satisfactorily address accountability, not specifying who is in charge of ensuring that workplaces comply with the Act and who can be held responsible if its provisions are not followed. So this is also a very big lacuna, that there is a clear-cut ambiguity on the accountability. So my question to you is, has any state government has ever tried to find out that whether the mandatory conditions of PoSH Act is being followed at the workplace or not? And the Act clearly lacks ambiguity on the accountability. You will not know who to hold accountable, whether the employer or the organization or the state government or the concerned authorities. So the Act is silent upon the accountability aspect. The law is largely inaccessible to women workers in the informal sector, as more than 80% of India's women workers are employed in the informal sector. So the Act is very viable in the formal sector, but if I talk about the informal sector, the women are not only aware that there exist such laws if they are facing harassment in informal sector also. Though the definition of workplace under the Act includes informal workplaces as well. But if we'll ask the women workers in an informal space, this law is very alien to them. They do not even know about the provisions of the Act, their rights, the redressal mechanism, whom to approach. They do not know anything about it. And with a large workforce, the informal sector is still not aware about the provisions of this Act. So this is a very big hurdle or a challenge in the effective implementation of the PoSH Act. Underreporting of cases. This is also a very big problem, because 90% of the sexual harassment cases at the workplaces are not only reported. Why? Because women feel threatened. They feel that they will lose their job if they go against their organization. They are, in fact, the power dynamics of the organizations make the women even more unsafe to report such cases. And that is why there is a huge amount of underreporting of cases. Inefficient functioning and the lack of clarity in the law about how to conduct civil inquiries. So, the Internal Complaints Committee under the PoSH Act can act as a civil court for conducting civil inquiries, because we wanted to save the women from the time-taking approach of the criminal courts and the criminal justice system. And that is why we made it a civil procedure. Like, the Internal Complaint Committee can act as a civil court, but most of the members do not have that technical know-how of how to conduct inquiries under the PoSH Act. Then lack of awareness in women employees about such committees and who to approach in the case of if they are facing harassment. So this is also a very big challenge, that even in the formal organized workplaces, the women are still not aware about the provisions of the PoSH Act. And even if they are aware, they fail to report such cases due to the power dynamics of the organization. And what happens is, when they reach court, when they gather courage and reach court, the court gives too much focus on the evidences. See, the lack of evidence does not mean there is an absence of crime, right? But in certain cases, the judiciary is focusing too much on evidences, and hence they fail to value the intent of this law. So this is what is happening. And what happens if the accused is acquitted? By lack of evidence, the women are definitely going to lose their job, and it will be a blot on their CV as well, because the market no longer will hire them, or the organizations will refrain from hiring such women. And this is also a sad reality that is going on in India even after the enactment of the PoSH Act. So what is happening? The woman who is a victim is facing the wrath of the inadequacy of the system. So these were some of the hurdles in the implementation of the PoSH Act. Now let us discuss the concerns flagged by Supreme Court in its recent judgment. So the first concern is lacuna and lack of uniformity in the implementation of the PoSH Act. As I have asked you before also, how many state governments are actually worried that whether the organizations in their state are following this PoSH Act or not. So some state governments are very proactive in nature, but some of them are not even concerned about the effective implementation of the PoSH Act, and this concern has been flagged by the SC in its recent judgment. Compulsory appointment of the district officer in each district. Before this, the state governments were not making any efforts to compulsorily appoint a district officer in each districts of their state, because they were reading section 5 as a directory provision and not a mandatory provision. Then the Supreme Court had to intervene by its current judgment, and the Supreme Court says that if we'll consider section 5 as a directory provision, it will frustrate the whole functioning of this act, the whole purpose of this act. So that is why the Supreme Court has made it now mandatory to have a district officers in each district of the state, so as to ensure effective implementation of this act, so as to ensure correct reporting of the cases. And you will find it very shocking. The Parliament in 2019 has made a statement in the Parliament that there is no centralized data maintained for these cases, the cases of harassment that is being faced by the women at their workplace. So there is no centralized data maintained about the cases of sexual harassment faced by the women at their workplaces. The SC asked the appropriate government or district officers in question to also undertake effort to spread awareness on the existence of local committees and make them approachable for the unorganized sector. So as I was explaining to you before in my discussion, that the informal sector is not only aware about this act, they are completely unaware about this act. They do not know their rights, they do not know whom to approach. They are not even aware about that they can report such cases. They can approach to the Internal Complaints Committee or the local committee for that matter if they are facing harassment at their workplace. They are unaware about these rights. So there is a immediate need to sensitize the women of in organized sector so as to ensure effective implementation of the PoSH Act or the Sexual Harassment of Women at Workplace Act. So this was all about the PoSH Act and its the need for its effective implementation. With this, we come to a conclusion of our today's discussion. We have seen what is the PoSH Act. We have seen how it came to India. We have also seen what are the hurdles in its implementation, and we have also analyzed the concerns of Supreme Court in effective implementation of the PoSH Act. Now let us see a practice question for your prelims examination. So the question is, consider the following statements. Your statement number 1 is PoSH Act is the manifestation of the Vishakha guidelines. Your statement number 2 is it is mandatory under section 5 of the act to have a district officers. Which of the following statements given above are correct? Your options are: option A is 1 only, option B is 2 only, option B is both 1 and 2, and option D is neither 1 nor 2. Kindly drop your answers in the comment box below. Now let us analyze a practice question for your mains examination. So the question is, discuss the opportunities and the challenges associated with the PoSH Act. So you will firstly write what is sexual harassment. You will write the definition as it is given in the PoSH Act. Then you will explain the history and the main legislative intent behind the enactment of this legislation. Now then you will discuss what are the challenges, like opportunities. Though there are a lot many opportunities, that it helps in effective prevention of sexual harassment at workplace. The accused can be punished. There is this internal complaints committee which is constituted, and it is a very important piece of legislation. You will write the challenges which I have discussed in my discussion today, that there are hurdles. Even if the internal complaint committee is constituted, it is illiquid, it is not paying attention. Then you will also write the flagging of the issue of appointment of district officers, and you will write about the need to appoint such officers, as has been mentioned by the Supreme Court in its recent judgment. And you will conclude holistically that this is a very important piece of legislation, but we need to make it more effective in nature. You can conclude by giving a very holistic approach. I hope this session was insightful for you. If you found today's discussion to be helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.